How do you analyze contract modifications and the pre-existing legal duty rule on a contract's essay question? Well, remember, to form a traditional enforceable contract, there's going to be 3 requirements: offer, acceptance, and consideration. And the good news is, thus far in our contract law video series, we've discussed all 3 of these requirements at great length. We know how a valid offer is formed, how that offer is accepted, and once we have offer and acceptance, how that agreement is supported by consideration. So at this point, we all know how exactly, step by step, a traditional enforceable contract is formed. So that leaves us with one more major issue we need to discuss in terms of these 3 requirements. And that's the situation that arises when we have a traditional enforceable contract. We have offer, acceptance, and consideration. We have a traditional enforceable contract, and the parties want to change that contract. They want to alter it. They want to modify it. We call this a contract modification. And the question is going to be, primarily, is the modification valid? But to determine whether a contract modification is valid, we need to know whether the modification must be supported by consideration. And the answer here is going to be that it changes whether the contract is governed by the common law or whether the contract is governed by the UCC. Obviously, if it deals with services or real estate, we know we're in the common law territory. If the contract deals with the purchase or sale of goods, we're under the UCC. So is consideration going to be required? Does the modification need to be supported by consideration? Well, the common law, in short, says yes. The common law says that a modification, if you're going to modify an existing traditional enforceable contract, so here's our traditional enforceable contract, our existing contract, if you want to modify it, right, you want to add, here's a little pen, right, say that you want to add some clause, some term, you want to change it or alter it in any way. Let's say we want to add a page to the back of this contract, right? We want to add a little addendum on the back and staple it to the back of the contract, right? We want to modify it. Does this modification need to be supported by consideration? Additional consideration that wasn't included in the original contract. Because remember, a traditional enforceable contract is offer, acceptance, consideration. So we already have some form of consideration if we have a traditional enforceable contract. When we're talking about this modification, we're really asking, do we need additional consideration to support this modification? And the common law says yes, and the UCC says no. The UCC says you don't need additional consideration. All you need is good faith. If the parties make the modification, if they enter into the modification in good faith, that's going to suffice. We do not need additional consideration. The common law says if you're going to modify an existing traditional enforceable contract, that modification has to be supported by additional consideration. And this idea of additional consideration is referred to as the pre-existing legal duty rule. So something we really need to understand here and talk about is this idea of the pre-existing legal duty rule. And we touched on this in our last video when we were talking about detriments and consideration in general, the bargain for exchange. We talked about this briefly. If you remember the example that I gave when we were talking about whether the promisee is incurring a legal detriment, one of the examples I gave was, imagine that I offered to give you $100 if you quit smoking tobacco for 1 year. And remember, I said, assuming that you are over the age of 18 in the United States, that is going to be a legal detriment because you are refraining from something that you have a legal right to do. You're legally permitted in the United States, if you're over the age of 18, to smoke as much tobacco as you wish. So when I say I'll pay you $100 if you quit smoking tobacco for a year, as long as you're over the age of 18, you are refraining from a legal right that you have. You're legally permitted to smoke tobacco. So in that case, you are incurring a legal detriment. You're refraining from something that you have a legal right to engage in. Okay, now, what if I said, I promise to pay you $100 if you quit smoking crack cocaine for a year? In that situation, do you have a legal right to smoke crack cocaine? No, you are legally required to refrain from smoking crack cocaine. As far as I'm aware, in all 50 states, you have a pre-existing legal duty to refrain from smoking crack cocaine. So if I offer to pay you $100 to refrain from smoking crack cocaine, you aren't sustaining a legal detriment. You, the promisee, are not incurring a legal detriment, which means we cannot have consideration. And that's the idea of the pre-existing legal duty rule. And it's important to understand the difference between me offering you $100 to quit smoking tobacco and me offering you $100 to quit smoking crack cocaine. Tobacco, you do not have a pre-existing legal duty to refrain from smoking tobacco. You're free to smoke tobacco as much as you wish, as long as you're over the age of 18. If you're smoking crack cocaine, you already have a pre-existing legal duty to refrain from smoking crack cocaine. So you're not going to incur that detriment. So if you understand that difference, contract modifications should be pretty simple. So the classic example that you're going to see here, and by the way, I would say on first attempt, out of the thousands of law students I've worked with that come across this fact pattern, I would say 70 to 80, maybe even 90% miss this question at first glance. So let's pay really close attention and think about the pre-existing legal duty rule and the fact that, remember, under the common law, contract modifications have to be supported by additional consideration. Okay, so here's the fact pattern. Let's say that I am a landlord and you are my tenant or my future tenant. So let's say we write up a lease agreement, which is a contract. And in this contract, I am agreeing to let you live in my apartment in exchange for $2,000 a month. So let's say you agree to pay me $2,000 a month in rent in exchange for living in my apartment, okay? And let's say it's a standard 12-month lease, okay? So 9 months goes along and the contract is performed. Each month, at the end of the month, you're paying me $2,000. You're living in the place. Everything is going great. Well, let's say with 3 months left on the lease, on the 10th month, you run into some sort of financial issues. Who knows, maybe there's an accident, you have to spend more money than you anticipated, so you're running a little short on cash. So you come to me, the landlord, and you say, hey Michael, the next 3 months are gonna be tough for me. I don't have as much money right now. Is there any way we can lower my rent until the end of the lease from $2,000 to $1,500? So I say, you know what? You've been a great tenant. You've been perfect this whole time. I really like you. I want to help you. Absolutely. Let's do this. So I whip out a pen and I mark up the new lease. I mark up this modification to say, on the original contract, let's say I pull out the pen and I cross out the $2,000 and I write in 1.5K. I write in $1,500 instead of $2,000. Say we both initial that change, we both sign at the bottom that we agree to the new price change. So it's all been agreed upon. You, the tenant, have signed it and agreed to it. Me, the landlord, I've said perfect, great, yeah, no problem. I want to help you out, and I sign it too. We initial it, sign it, all the formalities that are required. Boom, so we've got this contract modification from $2,000 rent to 1.5K or $1,500 rent per month. Let's say nothing else in the contract changes. All we've done is literally lowered the price $500 per month until the lease expires. So let's say that it goes to the end of the month, you pay me the $1,500 that we agreed to, and I turn around and instantly sue you for the extra $500. The question is going to be in court. For breach of contract, can I recover that $500? And the answer, to surprise to law students everywhere, is going to be yes, I can, because this modification was not valid. When we changed this price from $2,000 to $1.5, that modification was completely invalid. This does not apply. So the original contract controls, so you owe me $2,000. You only paid me $1,500. I can sue for breach and recover the $500 under the original contract because this modification was invalid. And the question is, why was this modification invalid? And some of you may know the answer right now. And if you do, pat yourself on the back. But for those of you who don't, no problem. Again, I would say 70 to 90% of my students miss this. So what happens here is, first of all, the first thing you had to recognize is this is a real estate contract, right? So we're in common law territory. A lease agreement is going to be governed by the common law. So we know that this contract modification has to be supported by consideration. Was this modification supported by consideration? And the answer here is going to be no. You had a pre-existing legal duty to pay me $2,000 for 12 months. That was the term of the lease. You had a pre-existing legal duty to pay me $2,000 every month for 12 months. So when we lowered this price from $2,000 in rent per month to $1.5 or $1,500 in rent per month, there was no additional consideration. You've incurred no detriment. The key, right? And in consideration, like we discussed under the pre-existing legal duty rule, you already had a pre-existing legal duty to pay $2,000 per month, and now we've lowered that to $1.5. So you had a pre-existing legal duty to pay the full price. Lowering it to $1,500 is not going to constitute consideration for the modification. So even though this looks like a fair deal, right? We both said, I looked you right in the face and I said, yes, absolutely, I want to help you, and I 100%, we signed it, we addendumed it, we put our initials, it was all done formally, and I was gung-ho to help you on this. It doesn't matter. None of that stuff under the common law matters. All that matters is, was this modification supported by additional consideration? No, you already owed me $2,000 a month. Lowering it to $1,500 a month and changing nothing else adds no consideration. You had that pre-existing legal duty to pay $2,000. You're not incurring any detriment. Lowering it to $1.5, there's going to be no consideration here, okay? So the modification is not supported. That means this contract modification is out. The original contract controls and a breach of contract action. That's why I would be able to recover the $500 at the end of the month. Okay, so how could we make this modification valid? Well, you would have to incur a detriment here, right? You would have to offer something in exchange for the modification. You need to say, okay, we'll lower the price to $1,500 per month in exchange for lowering the price to $1,500, for lowering the rent to $1,500 per month. I am going to repaint your lobby for you. Let's say it's an apartment building. Inside, when you walk in the door, there's a big lobby area, a big common area, and you say, you know what, I'm short on cash, but I still want to help you out. If you lower my rent, I will paint your lobby for you, right? And I say, okay, deal. In that situation, you're giving me something for the modification. You're incurring a legal detriment. You do not have a pre-existing legal duty to paint my lobby, right? That has value, and that's inducing my modification, right? So now we have a bargain for exchange, and you're incurring a legal detriment for the modification, right? And so the consideration under the original contract of $2,000 a month is not going to work. You can't use the same consideration in the original contract as your contract modifications consideration. That's the whole pre-existing legal duty rule. You have a pre-existing legal duty to pay that $2,000 a month. So you have to add something else to the pot. Even if we're lowering the price from 2K to 1.5K, you're going to have to throw something in. For me, you have to incur some legal detriment, basically, right? And what's gonna work there, you know, could be pretty small. Something like painting the lobby would probably work. Now our modification is supported by consideration. So if I sued you at the end of the month for breach of contract, this contract is gonna control with the lowered price term. I'm not going to be able to recover that $500, okay? So that is the main idea of contract modifications under the common law. The key here is to remember that under the common law, to modify a contract, you have to throw in additional consideration. Now, the only exception to this would be, and it's worth noting because it sometimes comes up, and it's not really an exception, it's a whole different situation. So what happens if we have a lease agreement for $2,000, right? And instead of modifying it, remember in this I said I pulled out the pen, and on the original contract I drew a line through the 2K, and I wrote 1.5K, and we both initialed it and signed it. What happens if we terminate the original contract? Let's say we both sit there, we put that contract in a shredder, we agree to rescind the original contract. We completely terminate it. So we shred this thing, right? We put it in a shredder, it's dead, it's rescinded, it's terminated, and we've done an outward sign of rescinding it, like putting it into a shredder, ripping it up, throwing it in the trash can. If there's an outward sign, like shredding it, ripping up the contract, and it's rescinded, okay? And then we write a new contract that is the exact same as the original contract, except it's got a lower price term. That is not a contract modification. That is a rescission of the original contract and a formation of a new contract. We do not have a contract modification analysis in that situation. It would just be, you would go back through offer, acceptance, consideration. That would be your analysis on the brand new contract. There is no modification if the original contract is destroyed, basically. If it's terminated, if it's rescinded, and there's some outward sign, whether it's ripping it up, putting it in a shredder, in that situation, it's going to be considered fully terminated. The new offer, or the new contract, even though it might look similar to the other one, and you want to think it's a modification, in that situation, you should analyze it as a brand new contract, not a modification, okay? So one nuance there. The only thing left is, imagine that this was a purchase or sale of some good, right? So we're in the UCC, it's the world's easiest analysis, right? At that point, all you have to ask is if the modification was entered into in good faith. And most people know good faith when they see it. If somebody's extorting the other party or something crazy, right, to modify it. If I'm doing something, you know, in just absolute bad faith, I know that you're hurting on money, and I say I'm going to turn off your electricity unless you pay me more money, you know, something like that. That's going to be bad faith, right? As long though as this modification is entered into good faith, which is what the fact pattern described, imagine that this original fact pattern I laid out with the lease agreement fell under the UCC, even though we know it doesn't since it's a real estate contract and the common law applies. Imagine we applied the good faith test in that situation where you come to me and say, hey, do you mind if we modify this contract from 2K to 1.5K? And I'm like, absolutely, you've been a great tenant. I would love to help you out like this. That's going to be a good faith modification. And under the UCC, that's valid. We don't need additional consideration. The modification under the UCC does not need to be supported by consideration so long as the modification is entered into in good faith. Okay guys, but that's how you analyze a contract modification with the pre-existing legal duty rule on a contract's essay. And at that point, we've discussed almost everything that could come up, all the major issues at least in a contract formation fact pattern. We've discussed how an offer is formed, how it's accepted, and we know once you have offer and acceptance, that's mutual assent between the parties. Once we have mutual assent between the parties, if we can show that that assent is supported by consideration, then we have a traditional enforceable contract, which brings up the issue from today. Once we have a traditional enforceable contract, what happens if we want to modify that agreement? And we know, right? If you're in the common law, then the modification has to be supported by consideration. If you're in the UCC, it's just a good faith test. And that's going to be it for contract formation. With that, guys, I'll leave you to it. I wish you all the absolute best. Hope this video was informative, and I'll see you at our next video.